Hello, beautiful people. Welcome back to our channel. There seem to be a lot of jubilations in the air over the hidden issues or legal issues that is coming to play and that's coming to light. A lot of persons have been wondering what is the hope for Mazi Nnamdi Kanu, judging the fact that there were lots of broadcasts he made, and a lot of people were really tense. Some were insisting that he should be settled out of court and all that, but it looks like there's a lot in the graveyard. There's a lot actually at stake, and Mazi Nnamdi Kanu seem unshaken based on the fact that there are some assurances he's getting, and we're going to share some of them. And it looks quite bold. It looks looks strong indeed, I must say. Before we go to the newspaper to find out why there seems to be so much hope and no fears at all around Mazi Nnamdi Kanu, like you subscribe to our channel by clicking on the red subscribe button beside it. You'll see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube, where the leader of the indigenous people of Biafra, Ipob, has urged the federal government, or rather the Federal High Court, to decline its jurisdiction to adjudicate of over the alleged charge of treasonable felony filed against him by the federal government. Kanu, who pleaded not guilty to the 7-count amended charges against him, noted that from the 7-count amended charge, the only element requisite to constitute and found liability for incitement allegedly occurred wholly and entirely in London, United Kingdom, and not anywhere within Nigeria. In his notice and preliminary objections filed against him, he argued that the alleged broadcasts were not shown to have occurred at sea or on the international waters aborting Nigeria, adding that I know as a fact that London, United Kingdom, is a sovereign state under international principal law, or rather under international municipal law, and has municipal laws punishing criminal offences. The preliminary objections filed by counsel to Kanu Ifeanyi Ejiofor further stated that I also know as a fact that jurisdiction is extrinsic to adjudication. It is conferred on a court. It is not intrinsic rather, that I know as a matter of fact that as the elements necessary to constitute incitement in the alleged several broadcasts of defendant applicant occurred in London, United Kingdom, and not in Nigeria. The court in Nigeria has no jurisdiction to try the defendant or applicant on any charge founded on any such alleged incitement, even if the defendant or applicant enters within the geographical boundaries of Nigeria. The affidavit in support deposed to by Chinwe Umeche equally averred that I also know as a matter of fact that the alleged offences for which the defendant was charged do not constitute terrorism offences in London, United Kingdom, where they were allegedly committed. That I am further away, or rather that I'm further aware that there is an obligation on the Attorney General of the Federation to maintain international cooperation for compliance with international treaties on terrorism. That the defendant was abducted from Kenya and consequently extraordinarily rendered to Nigeria without firstly subjecting him to extradition processing in Kenya and the proceedings in Kenya. I know as a fact that this is a violation of all known international conventions and treaties on extradition. That prosecuting the defendant on the 7-count amended would amount to allowing the complainant to benefit from their illegality and wrongdoing. That I am aware that he who comes to equity must come with clean hands, and no party should be allowed to benefit from his wrongdoing. That I know as a matter of fact that the extraordinary rendition of the defendant robs the honorable court of the requisite jurisdiction of trying the defendant on count 4, 5, 6, and 7 of the amended charge. That counts 1 and 2 and 3 of the amended charge were brought under a non-existing law. That count 3 of the amended charge relates to an offence allegedly committed in Ubuluzuzo in Ihiala local government area of Anambra State, which is outside the territorial jurisdiction of the Honorable Court, that I know as a matter of fact that an offence can only be tried by a court exercising jurisdiction over a place or area where the alleged offence was committed. That counts 4 and count 5, 6, and 7 of the amended charge do not disclose an offence or do not disclose an offence known to law, that there is no proof of evidence attached to the amended charge filed against the defendant, that even the purported proof of evidence to be relied upon by the prosecution does not disclose any prima facie case against the defendant, that from the list of exhibits and witnesses attached to the amended charge, there is nothing relating to or linking defendant to the 7 count charge, particularly counts 4, 5, 6, and 7 of thereof. That no final pronouncement has been made on the purported proscription of the indigenous people of Biafra, as the said purported proscription is a subject matter appeal in appeal number CA//214/218 pending before the Abuja division of the Court of Appeal. Now that's quite strong, which means they're actually appealing the issue of proscription. So why are they always shouting the proscribed the indigenous people of Biafra if they're appealing it? Wow, this is strong. Let's continue with the news anyway. That the defendant applicant cannot be arraigned anew or tried for an offence when the judgment that made the pronouncement on the instrument constituting a state of affair as such an offence is the subject matter of an appeal. That it will be most unfair, unjust, painful, wicked for the applicant to undergo the rigors of full trial when the amended charges as constituted does not disclose a prima facie case against him. That there is no ground for this honourable court to proceed with the trial against the applicant in the circumstances of this case. That the court has the powers and the duty to stop a prosecution which on the fact creates abuse and injustice. That it will be the best interest of justice if the present 7 count amended charge is struck out on all dismissed. Can also pose the following questions for determinations: whether the honourable court has requisite jurisdiction to try the defendant on the 7 count amended charge in view of the extraordinary rendition of the said defendant, whether the honourable court has the jurisdiction to try and defend or try the defendant or applicant for alleged acts constituted wholly by elements that occur within the geographical space of a foreign sovereign nation and outside the jurisdiction of the court. This is strong. They're now beginning to he's trying to trash out everything the federal government have actually submitted. We're going to stop there because quite a lot is actually at stake here. But from all indication, a Ejiofor is ready. It said whether the information contained in Court 567 of the amended discloses the commission of any offence known to law, whether the proof of evidence in support of the count charge 7 as amended discloses the prima facie case against the defendant. Accordingly, he urged that his extraordinary rendition from Kenya to Nigeria robs this honourable court of the requisite jurisdiction to try the defendant or applicant, which means they want to first of all finish up the issue of his extraordinary rendition first before any other thing. The strong one, honestly, is a very strong one. I guess that's why there seems to be so much delay. Let's meet in the comment section, please.